I think we're ready to go. Welcome, everybody. Happy Valentine's Day. My name's Stephen Wood. I am an uninvited guest on the traditional, ancestral, unceded, and occupied territories of the Musqueam, Squamish, and Tsleil-Waututh people, coming to you from the Allard School of Law in the University of British Columbia in Vancouver. Welcome to the last of our four-part series of webinars on youth climate litigation, where we are joined by youth plaintiffs and their counsel in four of the leading climate change cases brought by courageous youth in Canada and the United States against their governments for their failure to act urgently on climate change. And in all four of these cases, on slightly different legal bases, but basically the youth are claiming that their government's actions and inactions that contribute to dangerous anthropogenic global heating violate their constitutional rights. Today, we're going to hear from one of the plaintiffs and one of the plaintiff's lawyers in probably the best known of the children's or youth climate cases, the case of Juliana against the United States, which is a case brought in 2015 by 21 young Americans who filed this constitutional climate change lawsuit against the US government in federal court in Oregon, asserting that because of the government's affirmative actions contributing to climate change, it has violated the youngest generation's constitutional rights to life, liberty, and property, and has failed to protect, essential public trust resources. In 2016, Judge Aiken rejected the federal government's motion to strike the claim, and in the course of that decision, she famously wrote, quote, "The right to a climate system capable of sustaining human life is fundamental to a free and ordered society," end quote. But since then, the Department of Justice's long string of attempts to dismiss and delay the case has meant that Juliana has not yet reached trial. But in June 2023, a ruling put the case back on track to go to trial. And in December of 2023, just over a month ago, Judge Aiken denied the federal government's latest attempt to derail the case and ordered the parties basically meet to schedule the trial. If this happens, it will be the first climate trial in federal court in US history, following closely on the heels of held against the state of Montana, which went to trial and won at trial last summer in Montana State Court. And we heard from one of the plaintiffs and lawyers in that case last week. So welcome to this webinar, and we have quite a few people in person. Once I finish speaking, I'll turn the camera so that our speakers can see who they're speaking to. But I'm going to introduce the plaintiff who's with us today, Alex Losnak, and then let Alex speak. And then when Alex is done, I'll introduce Andrea Rogers as one of the attorneys. So I'm just going to read your bio, Alex. Alex grew up on an Oregon farm that has been in his family for 7 generations. His great-great-great-grandmother, Martha Poindexter Mopin, founded the farm in 1868 and was one of the first women in Oregon to own a ranch. And she founded it after having arrived in the area by way of the Oregon Trail. The Mopin Century Farm is a foundational piece of Alex's life and heritage, but the drought conditions, unusually hot temperatures, and abnormally large nearby wildfires are harming and will increasingly harm Alex's home. Alex started a climate change club at Roseburg High School, started the League of Umpqua Climate Youth, LUCY for short, and has lobbied state legislatures to pass comprehensive climate legislation. He has also conducted extensive research for this lawsuit, including uncovering President John F. Kennedy's knowledge of human-caused climate change some, what is that now, 60 years ago? In any case, welcome, Alex. Thank you so much for joining us. We are really eager to hear from you about your experiences in this lawsuit and your motivations for doing it and what you are learning from it. Thanks very much and welcome.
Thank you. Well, I really appreciate that introduction. Can you hear me all right?
Yes,
Everything's all good. Excellent. Excellent. And I see, there we go. Yes, I see a room full of folks. And it's an honor to be speaking at a CLE. As you know, as you just heard, my name is Alexander Loznak. I'm one of the plaintiffs in Juliana v. United States. Grew up on a family farm in rural Oregon. And joined the case when I was just 18 years old. This case has been going through the court process for about 8.5 years, believe it or not. And that is quite a long time in a young person's life. So a lot has happened since then, both in the case and in just my life and my experience. I actually just graduated from law school about 7 or 8 months ago and passed the bar exam and am now a licensed attorney in the state of Oregon. I believe I am the first youth plaintiff in one of the Our Children's Trust cases to make it all the way through law school and become an attorney himself. So I think that gives me a particularly sort of unique perspective on the case, having both been a plaintiff, been in court, drafted declarations, done some research behind the scenes, and really brought my testimony into the courtroom about the ways that I'm being impacted by climate change, but also having studied the case and had this strange and surreal experience of actually learning about my own case in a law school class while the case is still pending. I can't imagine there are very many people in the world who have done that, and it's quite an honor to both get to participate in the case and also study it and gain a deeper understanding of it as an attorney. So as you heard, the family farm that I grew up on has been in the family for a very long time in Southern Oregon. My great grandmother bought the farm back in the 1860s, and she was one of the very first women to own property in the state of Oregon. So I grew up both on the farm and also when I was a bit younger in the state of Montana, which is also obviously a very rural, very rugged place, and really grew to love the natural world, the environment, the forests of the Pacific Northwest, the wildlife that we have here, and that kindled a passion for protecting the planet and getting involved in climate change advocacy. I have the very stereotypical story that I saw the film An Inconvenient Truth not long after it came out, and that was something that really inspired me to get involved in trying to affect policy and do the right thing about climate change. As you heard, I got started pretty early when I was in high school, trying to get solar panels installed at the school. That was an interesting endeavor, ultimately not successful in actually getting the solar panels installed, but nevertheless kind of an early foray into advocacy, learning how government processes work, and also dare I say it, becoming a little bit jaded just about how difficult it can be to get government bodies to do anything, but they can, once you apply enough pressure and prod them enough to do so. After I graduated from high school, I signed up to be a plaintiff in Juliana versus United States. I had been following some of the other youth climate cases that had previously been filed, and became very interested in the court system as an avenue to really push climate change policy in the right direction and vindicate the rights of youth. I became very interested around that same time, around when I came out of high school, in the work of Professor Mary Christina Wood, who many of you in the room are probably quite familiar with. She's a law professor at the University of Oregon, actually taught me many years later, or I guess, 6 or 7 years later, my first year property class when I went to the University of Oregon School of Law. But she has written about how the public trust doctrine can really be used and applied to the climate change situation, as a basis for a cause of action to actually, for lack of a better word, force the government to do something about climate change. I became very interested in that after having followed developments in the political arena, both within the US and abroad, and just observing the failure of our elected leaders to take comprehensive actions that were needed to deal with this crisis of climate change, and also continuing to take harmful actions. Such as, and you'll hear probably a bit more about this from Andrea, but leasing fossil fuels from government-owned property, and subsidizing the industry, putting in place ineffective regulations, etc. So I became very interested in joining a case as a plaintiff, and I called up Julia Olson, who I'm sure you're all familiar with from having learned a bit about these cases, and said I'd like to be a plaintiff in this federal case that is in the works. And she agreed, and we put my name on the case, and the rest is history. That we filed the case in August of 2015, and it was that very same week that I actually went off to college, uh, all the way back in New York City at Columbia University. And that was quite a shift for me, having grown up in rural Oregon. I don't know if anybody in the room has spent time traveling around Oregon or traveling around sort of rural parts of the West Coast. I imagine it's really not that different from rural Canada or rural anywhere else, culturally, and politically, etc. So going from that environment to living in New York City was quite a change, and almost like moving to a different country in many respects, and a great experience for me, having grown up in such a different environment. So I went from, in quite a short span of time, being just pretty much normal high school kid, to being in New York City, being surrounded by journalists, politicians, world leaders, people who are really interested in what we're doing through the Juliana case, and rightly so, because we've been able to make a lot of progress to move the needle on climate change through this legal advocacy. Um, I should also take a step back and talk about some of my personal injuries and impacts from climate change, because that's really, really important to my role in the case. Having grown up on this family farm, I saw a lot of impacts from extreme weather and climate change firsthand. It seems like almost every year we break the heat record that was set the previous year. And this has been going on for, I would say, about a decade. The wildfire season in the West, the American West, and I'm sure the Canadian West as well, has grown dramatically. And one of the big factors contributing to that is climate change, is these record-breaking heat waves and droughts. And we've had numerous really severe wildfire events within the last decade. In 2020, during all the craziness around COVID, when I was living with my family, we had the worst wildfires we have ever seen in this region. The sky turned orange, deep, deep, dark orange, and I think there's actually a picture from that event in Andrea's slide deck, so you'll get to see that in a few minutes. But it was really not safe to go outside. I also have asthma, which makes those sorts of events particularly dangerous and harmful to me. But there's also commercial impacts on the farming operation from this extreme weather as well. We've been trying to grow hazelnuts, which are a relatively small industry in the United States. Most of the hazelnuts in the world actually come from the nation of Turkey, but we have a particular climate zone here in Southern Oregon that is one of the only ones in the United States that is suitable to growing those hazelnuts. So obviously, as the climate shifts, as things become warmer, it becomes harder to get a crop started. And we started trying to plant hazelnuts and grow them commercially. My family, that is, about 10 years ago. And the growth of these hazelnut trees has been severely stunted. And we believe that the extreme temperatures and drought that we've experienced are a huge contributing factor to that. So, those are just a couple of the ways that I'm being impacted personally. There's also things that I've brought up in the case around, uh, for instance, natural areas that I enjoy visiting and recreating, whether it be on the Oregon coast, in the beautiful Oregon old growth forests that we have here. And all of these areas are severely impacted and threatened by climate change, which is being, exacerbated by the policies of our government and governments around the world. Um, I want to touch on just a couple legal points on, and Andrea is gonna, I know, go deeper into the legal issues, but you can't, I don't think you can convince a lawyer not to talk about the law at least a little bit. And one of the really crucial, ways that this case has moved the law forward is dealing with the area of standing, and particularly convincing the courts that individuals have standing to be able to bring climate change cases really against anybody, against the government in particular, but that we have personal injuries that satisfy the requirements, the legal requirements for an individual to bring a case. And that is a really significant and kind of underlooked achievement of the Juliana litigation, is actually successfully persuading, the U.S. District Court here in Oregon and also the Ninth Circuit Court of Appeals that yes, individuals can actually bring legal actions arising out of climate change. We've had more issues, and Andrea will go into this, I'm sure, around sort of the redressability and what kind of remedy the court can award. But as far as the actual personal injuries being sufficient to, predicate a case on, we've been overwhelmingly successful. The U.S. Constitution, Article 3 requires a actual case or controversy to bring a lawsuit. I imagine there's a similar procedural requirement in Canada and in most countries, but the idea is to, have the legal process not be something analogous to sort of writing a letter to your senator or your member of Congress about some general grievance that you have with the way the government is operating, but it's got to be actually something dealing with a personal injury that you have. I would argue that maybe we should go more toward opening the courthouse doors to more people, and letting people who just do have some sort of general grievance about policy bring a case. But that is not what we're doing in this lawsuit. And there's requirements that the injury be actual or imminent. It has to be this particularized harm. And in the environmental context, under American law, um, that has generally been interpreted pretty broadly. So you could be just a person who enjoys, going and visiting a forest or hiking in a natural area, and you have plans to return to that place. And so you're injured if, say, the government wants to hold a timber sale in that area, that sort of thing. Where we've been able to push the law forward a little bit, is in actually expanding that to include individual injuries from climate change, which I think is a really, really positive development. I'm very proud to have contributed to that through some of my own testimony and writing, for instance, about a 30-page declaration that just goes through and enumerates all of the injuries that I'm experiencing personally from climate change. But those injuries are very particularized. They are very individual. And as a lawyer, like I've said, I do feel very proud of having been able to contribute to that. So that is just one area where this case has really been able to break some new legal ground, and I'm very excited about that. The other area that I'll just touch on as far as the legal case is the issue of causation. That also fits into the standing analysis, and that's another area where I'm very proud to have been able to contribute. And as you heard in the introduction, I did quite a bit of historical archival research to sort of build out the case, going around to these presidential libraries around the country. And this is back when I was an undergrad. And one of the most interesting and dare I say, damning things that I found in the course of that research was this evidence in the form of a letter to President John F. Kennedy that talked very specifically and attached an article that also talked very specifically about human-caused climate change and global warming resulting from fossil fuel greenhouse gas emissions. And just imagine that this was back in the early 1960s, that this was being talked about, that the Earth had actually already warmed by about 1 degree Fahrenheit. And I had this quite surreal experience of holding the very same letter, the very same piece of paper that the late President Kennedy had held in his hands, which, as far as we know, is one of the very, very first instances when the US government was put on notice that climate change was occurring, and probably the very first time that the President of the United States was informed of what was going on. And we've had, ever since that time, just a growing chorus of scientific warnings about, the trajectory and the direction that we're going with the climate system that have largely gone unheeded. And the government has basically continued on the same path of promoting fossil fuel extraction. So I'm very hopeful that we will have the chance to present, that evidence and all the rest of the evidence and expert testimony in this case at a full trial. I'm crossing my fingers that we're going to have this case resolved before my 30th birthday. But we're getting close to a decade here. So we really need to move forward, and it's an absolute travesty that the government of the United States, under 3 different presidential administrations, has basically continued to obstruct our path to trial. You'll hear about that more from Andrea, but it has basically pulled out every procedural trick in the book to try and appeal prior to trial, to appeal prematurely to the Supreme Court multiple times. Um, so my hope, and I may be a little bit naive in this, but I just persist in trying to keep some faith in humanity and in the United States government. But my hope is that before this case is resolved, the U.S. government and our top levels of political leadership will really reevaluate their adversarial stance toward Juliana, and work with us, recognize the potential of this case to really move the needle and push climate policy in the right direction, in the direction that we all know we need to go, and work with us instead of fighting us tooth and nail every step of the way. So we may have another term of President Biden, and my hope would be that at some point before he leaves office, that he will personally reevaluate the course that the Department of Justice is taking with respect to this case. Work with us, help shepherd this case onto a trial, and potentially to a negotiated settlement, which would likely occur after trial, if it occurs at all. So that's basically my piece, and I see it's been about 20 minutes, so I will go ahead and hand the microphone, as it were, over to Andrea.
Thank you very much, Alex. There's a round of applause in the room for you. I hope you could hear that. Before Andrea takes the mic, I'll have the honor of introducing her. Let me do that now. Andrea Rogers is Senior Litigation Attorney at Our Children's Trust, where she serves as co-counsel on the Juliana case and as lead counsel on AGP against State of Washington and Reynolds against State of Florida. After graduating from the University of California, Santa Barbara in 1998 and Arizona State University School of Law in 2001, where she served as co-executive director of Jurametrics, the Journal of Law, Science, and Technology, Andrea clerked for the Honorable John C. Gemmell. I'm not sure if it's Gemmell or Gemmell, you can correct me, Andrea, on the Arizona Court of Appeals. And she served also as an honors attorney for the U.S. Department of Transportation, in-house legal counsel for the Snoqualmie Indian Tribe, and staff attorney for the Western Environmental Law Center. Her law practice focuses or has focused on reducing pollution from industrial agricultural operations, protecting and enhancing in-stream flows for people and fish, and fighting climate change for young people and future generations. Before I hand it over, I should just let people know who are on the webinar that we will take questions after Andrea is finished speaking for both of our speakers. And if you have questions in the webinar, please use the Q&A function, which you should find amongst the tools in that sort of toolbar, which is usually at the bottom of your screen in Zoom. Please don't put questions in the chat and don't raise your hand. We will see the Q&A, and when it comes time for the question period, we'll moderate questions both from the floor here in the room and online. So with that, I will welcome Andrea to our webinar. Thank you.
Yeah, thank you so much, Stephen. It's always a joy to join you. We go way back. I first met you in Toronto, and I think the first time I had poutine was after we did a presentation in Toronto. So great to see everybody. I'm also going to be sharing my screen. So let me see. Hopefully that will work. Let me do the view. Let's see. There we go. All right. Is everybody able to see the screen?
Yes, we have got it.
Okay, wonderful. Well, again, it's such a pleasure to meet you. And I know a couple of weeks ago, you were able to hear a presentation about the La Rose case. And I am lucky enough to be our team member to support the La Rose litigation. So I know enough Canadian law to be dangerous, but I know you heard from the real experts a couple of weeks ago on that. And so I'm pleased to be talking with you about the Juliana litigation. And thank you, Alex. It's pretty incredible to have been see your journey as a plaintiff to now a lawyer, which is one of a few of the plaintiffs that we represent have decided to pursue the career in law, which is a good sign, I think. So just a little bit about what we do. We are a nonprofit law firm, and we exclusively represent young people against governments in climate change litigation. So we have a fairly narrow lane. This is what we do, and Juliana is really the leading case in that regard. I wish I could speak to you a little bit today about the science, because that's really what drives our work. It's really incredible, the climate change impacts that we are experiencing right now. In one of the cases that I lead is in Hawaii, and it's called Navahine versus Department of Transportation. And that case is going to trial in June of this year. And we just served our expert reports on the defendants a couple of weeks ago. So I'm quite up to speed on the best available climate science. And what we're seeing is nothing short of alarming. Just what we've seen in these last few years. And in Hawaii, it's particularly the corals that are really facing collapse. And it goes without saying, but corals feed billions of people. Coral reefs feed billions of people on this planet. So we are really facing a deep emergency. And it's our hope that the courts will be able to work fast enough to protect these incredible young people that we represent, seeking to protect their constitutional rights. So we have been doing this work since 2010. We've litigated cases in a number of different jurisdictions. We really learn as we go. The climate litigation field has been evolving and evolving rapidly. Climate change cases have been litigated in US courts for about 40 years. Juliana was really the first that took a human rights-based approach to that litigation, and that has really shifted the game. So now most of the climate change cases that you hear most about and that you'll be discussing is really focused on that human rights-based approach, just given the nature of the crisis and how significant the harms are today. And one of the unique aspects of our work is we really focus on challenging the governmental systems that are causing the climate crisis. So it really isn't individual projects, it's these government created systems that are the problem, whether it's an energy system that you're looking at. In Hawaii, we're focused on the transportation system that government creates and budgets for and plans and implements. They really touch every aspect of that, given approvals, different authorizations. That's the universe. And Alex talked a little bit about that with respect to causation and how we were successful in Juliana. But that's a little bit why our cases are unique, as opposed to a lot of traditional environmental cases really focus on a project by project basis, which is very important, but just doesn't get the remedy that we need to see in the climate change context. Here's just an idea, and I really see this map as a Juliana influence. So many of the cases that were filed around the world were inspired by the work that Alex and his fellow plaintiffs did. Different theories, slightly different kinds of plaintiffs, but really it is Alex and his plaintiffs inspired, dozens and dozens of cases around the world. We are involved in many of these cases, primarily La Rose, and we're filing amicus briefs and other filings in some of these other cases as well. So you can sort of see we're hoping to get more cases on an international basis going. There's certainly opportunities to do that, but here's just an example of some of the work that we're doing in our global program, which is managed by my colleague Kelly Matheson. Here's where we're litigating in the United States. Again, what's taken up the most of my time right now is Navahine in Hawaii. We have oral argument in Utah and Virginia later this year. We just got the defendant's opening brief, and so we are briefing that in the Supreme Court of Montana right now. Genesis is a case to watch. That really is focused on equal protection and discrimination against children brought by 18 youth under the age of 18 in California. We will be briefing that motion to dismiss in the next month or so. And lots to watch in the states. And I'm here to talk to you mostly about this incredible group of young people. And I love this picture, Alex, a little throwback, 2015. And then, your clients grow up and they do incredible things. And we were able to gather with our plaintiffs a couple of years ago. It's not an easy endeavor to, when you're that age, to commit to a project that ends up taking 8. Now we're going on the 9th year. So you really have to be resilient and committed. And this group certainly is. As we talked a little bit about, our claims are focused on the U.S. Constitution, the Fifth Amendment, rights to life, liberty, security of the person, similar to Section 7 of the Charter. That is at play in the LaRose case. And this case is focused on the United States fossil fuel energy system. So really all of the authorizations that the United States government controls and issues with respect to fossil fuels. So subsidies, permits, authorizing the leasing of federal lands and waters, setting fuel efficiency standards. All of what makes up the U.S. national energy system is what is challenged, the aggregate acts that make up that energy system. That's the conduct that's being challenged in Juliana. It's a big case. There's no secret about it. Here are the legal claims. Stepan touched a little bit about this. We're really focused on the right to life, liberty, security, equal protection of the law. That claim, Judge Aiken has actually dismissed in the case, so it's likely that claim wouldn't be tried, but there's a lot of crossover, just like there's crossover between Section 7 and Section 15 claims under the Charter. There's some crossover there, and similar evidence will be presented. And then the public trust claim as well is allowed to go forward to trial. This was a very pivotal moment, not only in the Juliana litigation, but in climate litigation as well. So this really inspired courts around the world and emboldened them to recognize that there is a right to a stable or life-sustaining climate system. Other judges have followed Judge Aiken's lead. Dissenting justices in the Supreme Court of Alaska, dissenting justices in the Supreme Court of Washington, now judges in the state of Montana, and the justices in the state of Montana will be deciding whether there is a right to a life-sustaining climate system and whether they will uphold Judge Seeley's finding. The Hawaii Supreme Court, the majority has recognized that there is a right to a life-sustaining climate system. Judges are sort of housing that right in a few different places. Some it has been housed in the right to a clean and healthful environment. Others have housed it in the notion of substantive due process or life, liberty, security of the person, like Judge Aiken did. But this is happening around the world. This right is being recognized as well. So Judge Aiken really set the bar and inspired other judges to similarly do that. So in a normal world, meaning a non-climate change case world, after you win a motion to dismiss, you'd be on your path to trial. There'd be discovery, some motions for summary judgment, things like that. But I like this picture because this is what the procedural scenario was for Juliana after the motion to dismiss. I think this graphic aptly describes sort of what we experienced. Here's just a few examples, and I have a more professional photograph or more professional diagram, but this one resonates with me because we really had never seen anything like this before. And the Department of Justice has never defended a case or fought a case like they have fought these 21 young people. It's really incredible. It's taught in civil procedure classes, it's taught in environmental law classes, it's taught in constitutional law classes. Because of the unique nature, and just climate change cases are just treated differently for a variety of different reasons, and that's something that you have to deal with as you litigate these kind of cases. And so we were hopefully on the other side of this quagmire, but we're sort of getting back a little bit back into it, as you'll see. So we bounced up and down. 10 days before trial, we were stayed. That was after we had done and took and defended 40 depositions in 60 days, which is quite unprecedented as well. Including Alex was able to have his deposition taken. I had the benefit of defending Alex in his deposition, which, you know, is an incredible experience. All of the plaintiffs do incredibly well with that. And ultimately, we ended up in the Ninth Circuit on interlocutory appeal. So essentially an early appeal before there has been a final judgment on the merits. And Alex talked about, you know, it had some incredibly positive rulings with respect to finding that the young plaintiffs had been injured and that the federal government is responsible for those injuries. They're a substantial factor in causing global climate change. But even though the government was found to have caused the youth's injuries, they found that the court was without power to order any kind of remedy in the case. And the basis for that, they found that the court didn't have the power to order one of the forms of injunctive relief that we had requested, which was a climate recovery plan. The court said Article 3 federal courts don't have the power to do that. So importantly, what they did is they dismissed the case for lack of subject matter jurisdiction. And they didn't say that was with prejudice, which is very important. Those two words, with prejudice, would mean that you can't file an amended complaint. But there's a lot of case law in the United States that if the court dismisses a case for lack of jurisdiction, it's always without prejudice. And the reason for that is it allows the party to present some additional allegations to prove that the court does have jurisdiction to hear and decide the case. So those are important buzzwords, with prejudice, that were not in the Ninth Circuit's decision. So just to give you a sense of kind of the kinds of injuries that courts are recognizing as cognizable, here's plaintiffs Isaac and Tia, again, experiencing the wildfire smoke that has shrouded, as you all know, you have lived through it as well, shrouded the Pacific Northwest, and significantly affects your lives as young people, not being able to go outside, being forced inside because of medical conditions, unable to go to school, unable to go outside, unable to see your friends. It really affects your lifestyle and your ability to lead your lives in significant ways. And the psychological harms associated with that as well are pretty significant and very well documented now in the medical literature. Alex, here's that incredible photo, Alex on his farm. I mean, that's wildfire. It's incredible. I mean, that glow is wildfire. And you heard of Alex's connection to his farm and his life there, and to have wildfire coming his way is extremely damaging to him and to his family. And the court recognized that the problem's approaching a point of no return. This is a very, very big deal. The court did not minimize the injuries or the harms that are at stake here. There's a very strong dissent from Judge Josephine Staten in the opinion, very critical of the majority's decision. Here are some of the words that she used, essentially saying that the government insists it has the right to destroy the nation. And that's essentially what it says. It says the executive branch's authority with respect to climate change should be unreviewable by federal courts. It's in a way, they think there should be an exception for climate change policy. Yeah, you could take them to court on immigration, but you sure as heck can't take them to court on climate change policy. And that's the position that they're maintaining to this day. And that is the position the Obama administration had. That is the position the Trump administration had. And that is the position that the Biden administration had. No differences between those three administrations in terms of how they are defending this case. Here's the more professional look at the procedural timeline. And this constantly has to get updated because we're not even, here we are a few months later and there's still more happening. But you can just see, the amounts, the procedural roadblocks that the Department of Justice has thrown in our way, all in an attempt to thwart the ability of these young people to get to trial and be able to present their extraordinary evidence that the district court or that the Court of Appeals recognized existed, based on a summary judgment record, not on a trial record. But you can just see what it's like. And this is, many hopes have been dashed along the way, and there's been many victories and positive moments as well. Because really the only time that the youth ever lost in their appeal was in that interlocutory appeal order. And they only lost on one issue, and that was redressability. And that's a jurisdictional flaw that can be fixed. And so they filed the motion to amend, which was granted by Judge Aiken, and should have put the case back on the track to trial. But that's not what happened. So in her order granting the motion to amend the complaint, that she has some very strong language about why do we have courts if not to protect and implement and enforce fundamental rights. Very strong decision that she issued, and also kind of in vanilla in a way, because motions to amend after a jurisdictional dismissal, it happens all the time. It's very routine, and district courts have very wide discretion to grant those kind of motions. So it was vanilla in that regard, but also very strong with respect to courts have a role given the constitutional controversy involved. Here's another one of the plaintiffs, and Miko has recently, I just prepared a declaration that we just filed in the Ninth Circuit explaining, just what it's like to grow up in this time of climate crisis and experiencing the delay. And Miko also is in Oregon and was stuck inside her home during the wildfire smoke, and then also had to live through the extreme heat dome, which I know all of you who are in the Vancouver area had to experience as well. Here's a couple more of the plaintiffs in the hearing. And I think I wanted to show this because it just goes to show the level of commitment. As a young people, I mean, they've literally grown up in courtrooms pleading for their case to be heard at trial. All the while, Department of Justice lawyers are constantly doing everything in their power to stop that. And I wanted to show a video, but I just didn't have enough time. But one of the Trump political appointees was giving a CLE about, he claims to be a hero because of his work on Juliana. And he said, when he was appointed, his #1 goal on day one was to kill Juliana. So this group of young people have really been targeted by the Department of Justice and treated differently than any of the other 40,000 cases that the Department of Justice is defending. So it's pretty remarkable that they're still going. And here was a little bit from Miko's declaration that she's trying to explain to the court to get, why, because the court is arguing now, or the defendants are arguing now, that there's no harm to the plaintiffs in delay. And so here, just in Miko's own words, sort of, how she views that, and why she still keeps going forward, in her own words. And the same from Levi. This picture is so old, you would not recognize Levi today, but he has been a plaintiff in this case for more than half of his life. And he had to relocate from his home on a barrier reef on the coast of Florida because the cost of insurance, the routine flooding, the having to evacuate from hurricanes, you can't live your life like that. And Levi and his family were forced to move inland, one of many families that have had to do that. So here's a long, wordy slide that has all of the most recent updates. So here's what I want to say, though. I really want to pick up on what Alex said, that, the extraordinary nature of what the Department of Justice is doing that. So after they granted the motion to amend our complaint, they filed a motion to dismiss that had all the same arguments that we'd already briefed many, many times and had already been decided. And then on December of this year, Judge Aiken denied their motion to dismiss. And so they moved for an extension, and without, we're not transparent with the court, but during that time, they, instead of, working on an answer, they ended up filing their seventh petition for writ of mandamus, their fifth in the Ninth Circuit, and their 14th motion to stay this case. So we've just filed our brief on Monday responding to their request to stay the case. And we are waiting for a decision on that from the Ninth Circuit with respect to their petition for writ of mandamus, which essentially would take the case away from Judge Aiken without her consent. It would take it up to the Ninth Circuit. We do not need to respond unless the Ninth Circuit orders us to. We have not yet heard from the court, so we don't know whether they will want to order. They can either order us to respond or they can deny the defendant's petition. So we will see what happens. That's sort of the current moment where we are. And what's interesting is, with respect to their motion to stay, you have to show irreparable harm, right? That you need to stay the litigation or else something really bad is going to happen. And the only evidence of harm from the defendants is their time and money spent defending the case. And you compare that to what the plaintiffs are experiencing with respect to climate crisis. And there's very strong case law in the Ninth Circuit, including decisions previously made in our case, that litigation costs and expenses are not enough to justify a stay. So it'll be very interesting to see how the Ninth Circuit treats their motion and what they'll do with the defendant's arguments that we think is improper. And frankly, if this case would have been decided in the normal course of litigation, it would have saved everybody time and everybody money. But the defendants seem to disregard that position. So I will leave it there so that we have enough time for questions. Again, I'm really pleasure to join you all, and Alex and I are here to answer any questions that you have.
Thank you. That's wonderful, Andrea. It really boggles the mind looking at those visual representations of all of the delay tactics that the Department of Justice has thrown at you. So, kudos to you and to Alex and all of the plaintiffs for keeping it going through all these years. I can't imagine, Alex, that you thought when you were just graduating from high school that you would have been admitted to the bar as a lawyer and the case still had not gone to trial. But now it's time for us to open for questions, and I'm in an awkward position where I have to turn my back on the camera to see the room, but that's okay. There might be questions in the room or maybe online. Do we have any questions online yet? So just a reminder to the folks online, use the Q&A function and toss in your questions. Kylie, who's here with me, will be monitoring those. If there isn't a question immediately, may I ask a question of you, Alex? And that is, well, just sort of a follow-up to what the comment I just made. How do you feel at this stage in the face of these interminable delays and intransigence on the part of the government? How are you feeling about the case?
Well, I feel good about the case. I don't feel great about the approach the government is taking toward it, and that's one of the things I was getting at, with my comments, that 3 different presidential administrations, which took very different approaches to climate change in other areas, in the international arena and other areas of policy, have basically taken the same approach to this lawsuit, which, you saw the various graphics that Andrea has. They have used every procedural trick in the book to try and keep this case from going to trial. I can't help but wonder, where is President Biden and I don't have a window necessarily into the sort of internal machinations within the Department of Justice, who exactly is making these decisions. But I really believe that just given the magnitude of the issues that we're dealing with in this case, it really deserves the time and attention of, the top agency heads and the President of the United States. I don't think that the just sort of bottom level trial lawyers, and I don't mean to insult them, because they're very intelligent. They're highly capable attorneys. They're taking the wrong position in this case, and I don't think that they are, frankly, at a high enough pay grade. The lawyers within the Department of Justice that are handling this case, to be making these calls about what approach the government should be taking. So I am just hopeful, and particularly, if and when this case goes to trial and we get a favorable trial ruling, that will grab the attention of the president, of the heads of, the EPA, the Department of Interior, these agencies that we're suing, and that they will, sort of grab the steering wheel, so to speak, and start, telling the Department of Justice to take a different tack and take a different approach to this case. I'm certainly not naive enough to think that that'll happen if we get another Trump administration, God forbid. But I'm somewhat hopeful that Biden, especially if he moves into a second term, might just be willing to take that step and really try to work with us rather than working against us.
Thank you. Is there a question from? Okay, I do see one. So in order to hear you well, it would be best if you actually come down. There are microphones at the front row. If you're stay back there, it probably won't pick it up. If you come just anywhere near the front row, like maybe over on that side, and then just introduce yourself and ask the question. From there, you should catch it, no problem. Stand a little farther that way, and they'll see you on the camera too. Go a little farther. It's on the other side of the person. Here we are.
I'm one L student. I'm Bonds, one L student of UPC Law. I was wondering what's the logic that substantiates that the climate change is infringing all the rights on the Bill of Rights in the US, like the ones that the rights that you are mentioning.
So did you catch that? If not, basically, what is the legal logic of the claim that the government's action in contributing to climate change violates constitutional rights? How do you lay that out?
Sure. Well, so in the US Constitution serves as a restraint on certain kinds of government conduct. So if you go back, the compact that the founders and citizens made with their government was we entered into a constitution that gave the federal government certain limited powers. But the citizens retained a large number of rights and made it clear that government's powers with respect to those rights are limited. So under our system of government, the executive and legislative branches cannot and do not have the authority to take certain actions that infringe upon rights of the people. So what you see in the context of climate change is it is affecting a number of different explicitly recognized rights, including the right to live, the right to liberty, which is recognized as a variety of different aspects, whether it's cultural autonomy or family autonomy, the ability to travel and to lead your life as you see fit. And then also security of the person. So there's a lot of science that confirms that young people's exposure to climate change is affecting their lives. It's considered to be what's called an adverse childhood experience. And the more adverse childhood experiences young people are exposed to, it really negatively affects children throughout their lives, up to and including early death. And so you do have significant links to climate change impacts harming the lives and liberties of children. And that really comes in through the scientific evidence that's so crucial for all of our cases. So I hope that, I hope that answers the question.
How do you draw the connection, though, Andrea, between the government action and those impacts on rights? Like, is it positive actions that the government has taken to authorize and promote and subsidize fossil fuels? Is it just a failure to act, a failure to pass adequate standards?
Yeah, and our case is similar to LaRose in that it's sort of both sides of the coin. So generally, because substantive due process constrains government action, you have to identify actions that the government is taking that are affirmatively harming you. So that's where it comes in. And the Ninth Circuit referenced, the subsidies, the authorization of fossil fuels on federal lands. Those are affirmative things that the government is doing. But there's also an aspect of substantive due process that if the government is the one that creates the danger, they have a positive duty to protect you from that danger they created. And that's called the state created danger doctrine. And it's akin to under the charter if you were to have a positive right. And so in LaRose, it's going forward potentially on the positive right claim. And that is similar to the state created danger. And so that's why the JFK document that Alex mentioned is so critical, because the federal government has known for decades that pursuing and depending on fossil fuels would result in dangerous climate change. And even though they knew that, they're still issuing permits to this day, contributing to the danger knowingly and with reckless disregard of the harm that it's causing on its citizens, particularly its younger citizens. So that's why we say our cases really have both sides of the coin. Most charter cases are involving affirmative action, right? So you're taking away the government is doing something. So it's that framing is really important because that's what courts are used to. Courts are, not used to this concept of a positive right, but we saw with Justice Rennie's decision in LaRose that climate change may be the circumstance where it triggers that duty to protect.
Thanks, that's really helpful.
And I would just add one thing that one argument that really resonates with me is that really all of our constitutional rights are predicated on the right to life. If you cannot live, you cannot exercise any other right, any other of the sort of basic freedoms that we take for granted. And one of the things that I've been very proud to help contribute to in this case is really demonstrating that the consequences of climate change quite literally threaten our lives. There's language from some of the decisions that we've gotten from the District Court and the Ninth Circuit Court of Appeals calling the consequences of climate change apocalyptic. There was a movie that came out a couple of years ago, I believe called Don't Look Up, which is basically an allegory for climate change, where there's a meteor coming toward planet Earth. And I think it's important that we kind of recognize that the consequences from climate change are on par with that sort of disaster, and the Constitution becomes meaningless if the planet is just a smoldering heap of ash. So, if these are more than just words on paper in our founding documents, they have to have some teeth to be able to protect us from these potentially catastrophic harms.
Thank you, thank you. Is there another question in the room or is there one online?
I have one.
Okay, oh yeah, you want to be seen, all right. It's good to be seen.
Hi, my name is Kylie. My question is for Alex. Less of a legal question and more of a political discourse question, because you talked a little bit about rural Oregon and maybe the politics of that. And unfortunately, climate change is a highly politicized issue. Have you found that the litigation is a good way to start a conversation with people, or is it too adversarial to kind of open that door? And just kind of, has it been a way to maybe talk to people who don't buy in?
Yeah, I think it has. I think it has. And I think obviously we've spent quite a bit of time, both Andrea and I, talking about, the legal aspects of the case and some of the judicial precedents that we've been able to set. But I think we also shouldn't overlook, the impact of raising awareness, and getting the conversation started, pushing the ball forward in terms of how people conceptualize of these issues. We filed this case back in 2015, and climate change definitely was on the agenda. It definitely was something that was being talked about a lot at that point. But I think there's been really a shift in consciousness in those intervening years to really recognize climate change as this existential threat, this issue that's not just somewhere way down on the politician's speech or whatever about we're going to list this after we talk about whatever education funding or something, but this is really one of the very, very top most important, if not the most important thing that our government needs to be dealing with. And I actually do credit this case not exclusively, but to some degree with kind of developing the conversation at a national and an international level, along with activists like Greta Thunberg, of course, and the Sunrise Movement, and many of these other sort of youth-led movements and organizations. I think it's similar to a lot of other social movements where often, in order to really force the issue and bring it to the top of the agenda, you need to have the people who are directly impacted be leading the march, so to speak. The civil rights movement being led by African Americans in the United States, the women's movement or LGBTQ plus movements being led by people who really have a direct personal stake in those issues. And I think younger people occupy that space and occupy that role. So yeah, I mean, I'm definitely very proud of the way that we've been able to shift the conversation about these issues.
Can I ask a follow-up on that, Alex? So really, you and the 20 other plaintiffs are standing up for an entire generation, which is an amazingly courageous and inspiring thing to do, but it's also a very heavy mantle to wear. Can you talk about the time, energy, and emotional resources that this lawsuit has requested of you and where you find them?
Yeah, and I can, and those resources are significant. I am not counsel on this case. My day job now is actually in insurance law, believe it or not, on the good side, representing people against the insurance companies. I should make sure to note that. But nevertheless, this case has been in the courts for close to a decade, and it's been quite a roller coaster. Wondering when we're going to go to trial. We had a Supreme Court decision stopping the trial, I think, within a week of the scheduled trial date back in, I believe, 2018 when I was in college. And it has been challenging because, I'm dealing with these personal injuries from climate change. I'm also, on a certain career path, which is something that I'm choosing to do. It's not something that's being thrust upon me, but it's something that I'm choosing to do, and it's demanding. I mean, as everybody in the room knows, going through school, and of course, in the United States, law school is exclusively a graduate level program, unlike in most other countries where it's you just go to college and study law. So I've been on this quite demanding, educational pathway, living in New York, sometimes flying back to Oregon for court hearings, catching a red eye flight to go to a court hearing the next morning, and then getting back on the plane to get back to school. And it is challenging. And there is a certain element of challenge also to just being in the public eye, having the eyes of the world on you to some degree. There's a cost to that, and it's something that I have enjoyed doing, and if I were to go back, I would do it again. But there is something, just it wears you down in a certain way, I think, to be on a platform and on a pedestal for the whole world, and having to sort of represent a movement and represent an entire generation.
I'll see if there's another question. Oh, it looks like there's a question online. Kylie will read it out.
Yeah, so this question is from Will, and he's asking, do you have any hypotheses as to why there's been such consistent resistance against bringing Juliana to trial across administrations, regardless of their stance on climate change?
I've been talking quite a bit.
Go ahead, Alex. You go first.
No, well, no, you go ahead, because I was saying my vocal cords are getting tired here.
No worries. My hypothesis, it's because they know they're going to lose. And they don't want the devastating evidence of their affirmative policies that knowingly harm children coming to light. And I honestly think that's what it's about. And I think what Alex said is really true as well, that the case gets absorbed by the lawyers who absolutely do not, they shut down as to what this case is really about. So much so that we had a meet and confer yesterday with defendants, and they wouldn't recognize that the Constitution preserves the right to life. They honestly just couldn't say that. I mean, it was incredible. These are wonderful, incredibly academically strong lawyers who couldn't recognize that young people under the Constitution have a right to life. So it's like, it boggles the mind. And it's incredibly damaging what they have done in defending these cases. But they go to the mat to their own detriment and are taking positions that are contrary to their clients' own public sentiments. Are you telling me the EPA disagrees that children have a right to a healthful life? That's not what their documents and public statements all reflect. So that's my hypothesis, for what it's worth.
And I concur completely in every point that that Andrea just made. As I kind of got at a little bit ago, I don't have a perfect window into the internal decision making in the Department of Justice and who is actually making the call. I really believe that the person making the final calls ought to be the President of the United States, because to borrow a phrase from Ronald Reagan, the buck stops at the president's desk. It doesn't stop at some lower level trial attorney's desk. And what we're really trying to do with this case is not just vindicate the rights of youth, but actually push and move the climate policies of a nation, the biggest, wealthiest, most powerful nation in the history of the world. and decisions, relating to that project ought to have at least some input from the democratically elected president.
I think it also shows how threatened they are by this lawsuit. So in that sense, I think it's a real accomplishment on your part that they are clearly so deeply threatened by it that they resort to these tactics. Can I just ask one final question? This one would be for Andrea, and then we'll let you go. You mentioned, Andrea, that the Ninth Circuit's decision opened the door for amending the pleadings to address that standing issue. Are you able to tell us how the pleadings were changed, sort of what changes you made in order to overcome that and to
Sure.
be back on track towards trial?
Yeah. So what the Ninth Circuit did is they said, it's not within the court's power to issue injunctive relief and a climate recovery plan. So we took out that request for relief, and instead we focused on a declaration that the fossil fuel energy system is unconstitutional. Now, we had declaratory relief in our earlier complaint. And what the court said about that was, well, we're not sure whether declaratory relief would redress the injuries. So all of our new allegations in the complaint included facts as to why declaratory relief would serve as partial redress, which is what our burden is. So, for example, if the nation's fossil fuel energy system is declared unconstitutional, the defendants would change their conduct because you would assume that the government would follow what a court order says. And there's long-standing judicial precedent that declaratory judgment satisfies redressability. And it's just, again, in the climate change context, courts have struggled with applying that traditional precedent.
Well, thanks. That's really helpful. And I think with that, I'll ask everybody to join me in applauding once again. And huge thanks to Andrea and to Alex for joining us. And we will be watching the progress of the case intently from here north of the border. So thanks a lot.
Yeah, thanks you guys. Stephen, always great to join you, and keep up the great work, everybody.
Yes, and I appreciate the opportunity to be here as well. Thank you.
Thank you.
Bye-bye.
Bye.
Bye.